Ms. Lyman, just to be clear, what date was that? November
10th
10th.
at like 9 in the morning.
She has not.
She is not. She's asking.
Yeah.
It was like the same outfit like on today. It was like a tannish, little pinkish color that you
Tannish.
like the hijab.
Okay. Give her Ann's email and have her send it.
Okay, pause right there. This case is already turning into a classic landlord-tenant credibility battle. Notice how the tenant is trying to establish a pattern here, not just one random incident in court that matters, one isolated event. Maybe coincidence, multiple alleged visits, contractors, people walking around the property. That starts sounding a lot more like harassment or interference.
It wasn't the first time that somebody had walked around the house. She sent, I believe, her contractor before them.
A lot of Muslim women in the neighborhood. A lot of women wearing jobs in our neighborhood.
And what's your argument in terms of the interference with her possessory interest?
There's been no facts presented other than this person who walked to the back of their house about interference with her possessory interests.
Okay, so that, and I hear you, counsel, but can I just say that? And again, you weren't here when that other case, and when I was coming back to you by decision, actually, she's put forth other claims of where your client has gone to the house. This one that she put forth today is one that wasn't included in that.
And here comes one of the biggest moments in the hearing. The judge starts comparing today's testimony with previous testimony. That is dangerous territory for any party in court. Judges keep mental receipts. If your story shifts even slightly from hearing to hearing, credibility starts collapsing fast.
Well, I know that you were not again. What the heck? I'm sorry.
The only time I was at the house was when he was court ordered. I haven't been at the house since. I don't go to the house.
Oh, okay, all right. There was a court. I know that there was a court-ordered inspection
Yes.
house, and she was
because there had been problems with coming to the premises and then claims that she wasn't able to get in.
right. You were here. You were there at the inspection, right?
Yes.
Okay, she was there at the inspection.
Correct.
Me and I were
Okay.
there. I haven't been back
You've not been there other than.
other than driving by.
You already talked about driving by.
Yeah, just to make sure the house is still there.
You've not been on the premises
No,
except for
Have
that
you
inspection.
sent others on the premises?
no.
You've not authorized anybody to be on the premises, Ms. Anderson?
No, I don't even know if it's still there. I drive by every now and again, to make sure it's still there. But I don't.
Okay, you already said that. Okay.
I'm gonna say, counsel, that, and again, you're at a slight disadvantage that doesn't quite fit with what's been presented to the court previously. So, all right, you sent that video.
Yes. I said,
All right, so Ann has it.
She said she'll let us know when she receives it.
All right, so what I'm gonna do is I'm gonna stand in recess, and counsel, I think we have your email.
I don't think so.
No, we don't.
I'll give this lady.
So
Yeah.
why don't you give it to her? And then what I'll do is I'm gonna take a recess. When it comes through to us, we will send it right to you, counsel.
I'd appreciate that.
Because that way I know it will go to your phone because you've been answering it all. No, I'm just kidding. All right.
I'm not going to lie, the judge sneaking in that little joke about answering the phone. That's one of those subtle courtroom moments that actually tells you a lot. Judges often use humor to cool tension, but it can also signal who they think has been difficult during the process. Tiny moment. Big undertone.
Spam calls that are spam.
No, it's okay. I understand. Our court's going to stand in recess. Everybody can be paid.
Bye-bye. Thank you.
The court has had an opportunity to review the videos and submitted by the defendant. Is there anything that plaintiff wants to say regarding those?
We know nothing about the person being there. We don't recognize the person or the car.
And Ms. Lyman, how are you so sure that it was Miss Anderson there?
The guy, he was there before by himself taking pictures inside of the basement. And then
He was what?
there before taking pictures inside of the basement. And then this time,
What do you mean he? So I recall the issue regarding the basement. You're saying this guy entered the home.
no, he didn't come in. That's who was taking pictures outside in the window. Like through the basement window.
That you had talked about before.
And then I seen her, that's why the hand was up when the car had came back past.
So your testimony is you saw Miss Anderson in the vehicle.
Yes.
On the, what would have been the third video that the court received.
It was the guy coming back around from the back of the house after he seen the camera.
Well, no, I think I may have received them in a different order. But the last one I had was actually, it looked like the back of the premises and there was a deck.
Yeah.
That, the camera, the deck I'm seeing, is that the deck that's attached to the premises you rent?
Yes.
Okay. And Miss Anderson, you're indicating that you know nothing about that individual. Ms. Lyman, you're sure that that's the individual that was taking pictures inside the premises?
Yes.
I never.
They
seen
never
anyone
came
in the-
inside. They were just taking a picture from outside in the basement.
Right, right. What were you going to say, Ms. Anderson? I want to give everybody an opportunity to say what they're going to say.
I never sent anybody to take pictures of the basement. You said you let somebody in to take pictures of the basement. I never sent
No, she
anybody.
did. She didn't let someone in. He stood outside and took pictures.
I didn't send it.
Anything else additional from either side before the call rolls?
Not from plaintiff.
Anything else, Ms. Lyman, you want to tell the court?
No, I'm just trying to make sure that the only thing that I have left to pay is the last 3 months, which is the 9,900. Correct.
Well, okay. I'm just gonna, well, I'm gonna do it this way. Anything else you want to say? And I'll let you know what you have to pay.
No, not really. I just don't think I should be responsible for court costs, just because when we started coming, the rent was already paid. And yeah, about the water bill, I don't really feel like I should be responsible. Just she took it out my name, paid it herself. But if I have to, I will. Just
What I'm gonna do is I'm gonna render my decision, and I'm gonna do it this way. The original case that was filed, which is, and let me just get it. It's 25-1C-2176. And that's the one that I'm going to render the decision on. Two, 176. All right. And the court has throughout this entire thing, first of all, reviewed all of the documents presented by the parties in detail. And frankly, am unsure, except as to really what is animosity between these parties as to why there is so much stuff here. And from the perspective of the plaintiff, I would just indicate that the many of the allegations made by the plaintiff regarding her need to get into the premises, certain things that need to be looked at, and all of those things, quite honestly, the court views as just some pretext to interfere with the possession by Miss Lyman. There wasn't a need. We went through, and just by way of example, we went through a whole seemed a series of hearings regarding the looking at something in the basement of something that potentially could occur that she wanted to get in the house. But Miss Anderson was really letting her.
Now, this is the turning point of the entire case. Listen carefully, because the judge is no longer just talking about unpaid rent, he's talking about motive. Once a judge starts using words like pretext, harassment, and control, the courtroom energy completely changes. At this point, the landlord's strategy is officially under the microscope.
Her true motivations be known, because every time she would indicate that she needs to look in to make sure that the premises are in some way damaged. And there was no indication whatsoever that Miss Lyman had done that. She was then at another previous point accusing Miss Lyman of not being the actual tenant, going so much to the extreme of asking the court to tell her to turn on the camera because that wasn't the person that she rented from and that she was dealing with somebody else. Every hearing, the person that's been appearing has been Miss Lyman, this Miss Lyman that I see here today. No one else has appeared. It also seems a bit disingenuous for the plaintiff to say that, because there would have been in-person contact prior to the rental in which she rented to Miss Lyman, and the like. Miss Lyman may have had people there. She may have had other things, but Miss Lyman has been the one here and been the one taking responsibility for that. So I don't think that Miss Anderson, frankly, I'll just be blunt about it. I think she wants to have control of everything, including Miss Lyman, what Miss Lyman's doing, who Miss Lyman has there, and the like. And none of it makes much sense to me. If she wanted to inspect for damages mid-lease, then inspect for damages mid-lease. But she came in here accusing Miss Lyman of fraud. That has not been substantiated in any way whatsoever, that Miss Lyman was somehow fraudulently renting the premises. It was just said that that was it, and that it wasn't Miss Lyman. And, in just over and over doing that. And I don't know why Miss Anderson wanted to do what she was doing, but it just throughout the course of these proceedings and hearing after hearing, just this sort of berating of the tenant, saying that she wasn't doing something, just continued. While I've heard what Ms. Lyman has said and said through counsel about not knowing that person in that vehicle, I am having a very difficult time believing that to be the case, because there were people coming, testified by Ms. Lyman before that there were people coming to the premises, all coinciding with Miss Anderson wanting to get in. Frankly, if this were just a simple issue, and it should be, and that's how the court's going to view this case. It's a simple issue. This is a non-payment case. That's all that it is. There has been no proof whatsoever presented to the court that Ms. Lyman has damaged the premises, is causing any waste or destruction of those premises, or is in any way abusing the premises or violating any terms and conditions of her lease. But what I do think is that she's been harassed by Ms. Anderson. And while it may not seem much, when the water bill was coming out, and that kind of popped into this case at some point, she was even in court berating the defendant about paying the water bill. Now, certainly the water bill should be paid, and there are just different ways that landlords go about doing that. But she just continued to go after Miss Anderson about paying the water bill. Kept saying the water bill was somewhere around $1,800. The only bill that I've received today is for $1,315.83. She claims that there are these other payments. I don't know that to be the case. But that's all I have in terms of the water bill is the $1,315.83. I then have in terms of rent not paid, and I think it was explained to Ms. Lyman that the rental period starting on the 5th, but her lease doesn't end till the 4th day of the end of the term, is that 30-day or month period. So it's not like she's being shorted. She's not entitled to any type of credit for that. But as it regards the rent on the premises, there's a total amount of $19,800 owing in rent. So when I take that and the water bill together, which the water was supposed to be paid by Miss Lyman, I come up with a total amount of $21,115 that is owed by Miss Lyman. Now, I've not made any deductions for what's been paid in at this point. That would be the aggregate amount due. I am concerned that there are then these additional late fees added on. And late fees should not have been charged for the defendant. Whether she paid it to the court late, there are remedies for a landlord. And let me just put it this way. That's part of the problem is that Miss Anderson tries to make her own rules. And she was paying escrow to the court and should not have been charged late fees. Miss Anderson's justification, as she blurted out, as she typically does, was that she paid the rent late to the court, so therefore she's entitled to a late fee. Not the way it works. The landlord has certain remedies.
This is actually a really important legal lesson for renters and landlords watching right now. The judge is explaining that escrow payments to the court are not the same as simply refusing to pay rent. That distinction can completely change a case, and honestly, the landlord trying to stack late fees on top of escrow payments clearly did not sit well with the court.
If she were late paid to the court, which, quite frankly, Anderson has been able to take advantage of with the whole start of the trial in this proceeding by an immediate trial. But it doesn't give you a right to a money judgment, but gives you a right to an immediate trial. There are those things, but the late fee, not going to do it. So claiming some $900 in late fees, I'm going to take off because that's what's been paid into escrow. So $300 comes off of that. So of late fees, there was only $600 for late fees instead of the 9 that's claimed. Now, the other problem that I have is that I don't know where Miss Lyman's security deposit is. I can't get a straight answer. What I know is it apparently is commingled with the funds of the plaintiff. It's absolutely inappropriate under our statutes and should be held in a separate account for which Ms. Lyman, because it was really her money that the landlord is holding, has to be notified as to where it is, the financial institution and the like. That is a clear violation of the law in the way that Ms. Anderson is conducting her business. I also don't know that her counting is all correct, because there were certain numbers that had to come off and come on, and somehow the notice that was sent on this case would have been incorrect. The notice that was sent to the tenant regarding the amount she owed would have been incorrect, because there was at least the $100 credit, and then presumably other credits that went to the tenant. Credits of, and I say it this way because it's money that she's paid. It doesn't necessarily change the bottom line, but it's certainly money that she's paid. And Miss Anderson knew or should know that she's received the funds from Miss Lyman. But somehow or another, Miss Lyman has to get herself here to explain to the court that I made these payments. There isn't a ledger, in the sense of a ledger, of her payments each month, because apparently Miss Anderson believes she didn't have to keep a ledger, an account ledger, until the time that she filed the notice, or until, actually what she said is until she paid into escrow. I don't even know where that comes from. That doesn't even make any sense. And certainly it's not a sound business practice by any stretch of the imagination. So what I have is, I have, with late fees, rent, and water, I have the tenant owing $21,715. She has posted, and counsel, remind me, what were your costs that you were claiming?
Costs are $183.59.
Okay. And while Miss Lyman doesn't believe that she did have the cost because rent was paid, I don't find that necessarily to be the case. I think the case, the original case, could have been filed. But it just wasn't. I mean, it could have been filed. It was filed. I'm not even clear when I look at everything that it needed to be filed. As it seems to me that for the most part, Ms. Lyman finds a way to get herself ultimately paid in full. And I'm gonna say this way. I think Miss Anderson was trying to harass Miss Lyman. I've said it in the regard to how she handled her tenancy, but I also think, and this was not certainly counsel's doing, But there's a case that was pending before the court that the court was coming back to render a decision on. And for some inexplicable reason, Ms. Anderson files a new case that then gets served on Ms. Lyman as, frankly, as the court interprets it, is just an added attempt to try to pressure Ms. Lyman to pay. The court never got a straight answer as to why this was even filed. But I just find it odd because also, and falsely, at least based upon what's been claimed here, in that complaint, she alleged $1,500 water bill, which supposedly was due October 6th. Now, I've never seen a rounded off water bill. I'm sure it exists someplace, but I've never seen one like that. And that's what she put on there. And again, I think it was just an attempt to try to pressure Ms. Lyman into doing something that maybe she was entitled to. But again, I could never get a straight answer as to why this next case was even filed. It made no sense to me whatsoever. This action was already pending, and again, it just made no sense whatsoever from the court standpoint that it was filed.
Wow, did you catch that? The judge just awarded money on the counterclaim for interference and harassment. That does not happen casually. Courts are usually very conservative with these claims, so when a judge openly says the tenant's peaceful enjoyment of the property was disrupted, that's a serious statement.
Because of all of the harassment, I think intentional interference with Miss Lyman's quiet and peaceful enjoyment of the premises, what the court is going to do is the court is going to award on her counterclaim on that $1,700 to her. That would bring the plaintiff's judgment to a total amount of $20,015 plus the $183.59. And counsel, I just want to make sure which case are you getting your costs from? Because is that the new filing or the old filing fee?
We became involved in this case. I mean, in his proceedings after the second case was filed.
Correct. So that I just want to make sure those are the costs you're giving me is from the second.
Well, no, actually, her figure is the cost come from the first case. Is that right?
I was combining.
She was combining them.
Pardon?
She was combining the two cases.
It was the first case. I don't know.
Oh, you don't know. Well, we'll just take the filing fee and the service fee and filing fee was what, $7,500?
No, well, here's the problem. On the first case, I have a filing fee of $130 and a $55 filing fee on the second case.
Okay.
I have a service fee on the first case of $32.30, as well as $32.30 and $32.20, respectively, between the cases.
32.30, 32.30 and 32.20.
So, yeah, so here's what I'm gonna do. The only cost I'm gonna award, counsel, is I'm just going to award the lower of them And so I'm just going to award 87.20 in cost.
Okay,
Because and again, it's on a case that should have never been filed, but that's the way I'm going to do that. And that would make the total judgment to the plaintiff. If they have me do math here, but 0, 1. I get $20,102.20 is the total judgment amount. And this I am $20,120
And $20.
or 20102.20.
all right, okay.
And then Ms. Lyman has posted into escrow, subtract off of this $8,870.
May I ask, has the court determined that that is the correct figure? Because it was 66 when I came in this morning.
There were 66, and then there was another. I had determined that there was
Okay,
2,000. Yeah, posted.
okay.
Ms. Lyman, you have your hand raised.
Yeah, because that doesn't seem right to me. If I only owe, the last 3 months, that's 9,900. With the water bill, that should only be $11,000. And then
11,000. Correct. You know what? I know part of what. So here's what I did. I'm only going to. So the total figure that I came through with rent, water, and late, that we just went through, is $21,015. Okay. I'm awarding them cost of, let's say,
8720.
187.20. Would then bring the total amount of their judgment amount up to $21,802.20.
so even in the prior proceeding, when she said she wasn't counting,
I only gave late fees for 4 of those months.
even though that she had said before.
I understand what she said, but under the lease, she's entitled to.
Even if she said it, or even if it's on recording that she said it.
So how many times do you think you're going to answer the question and get a different answer from me?
You can feel the frustration building here. Miss Lyman keeps pushing back on the math, but the judge is basically saying, I already factored your harassment claim into the numbers. This is one of those moments where courtroom emotion clashes with courtroom procedure. Emotionally, she feels wronged. Legally, the judge believes he already compensated for that.
Well, I think I'm pretty clear in what I said. And then I'm going to subtract out from that figure the $8,870.
Which gives you 12,920,
12,920.
32.
All right. So after the escrow is released to the plaintiff, that would lead to a judgment of $12,932.20.
Even though half of those months I've been harassed.
I gave, you need to listen to everything I said. I gave you a credit of the total amount of $1,700. That is for the harassment that you received. Really what is interference with your possessory interest to the extent it was interfered with. I gave a $1,700, which I will tell you historically is a large amount for that type of claim from this court. But I think that,
Does that need to come up with that?
no, I already took it out here. Okay. So I gave you credit against that amount because this number would be a lot higher otherwise. Right? It is nowhere near the figure that we started out with of the 22, almost 22 and a half that would have been owed, which would have then gotten us somewhere in some bizarre like neighborhood. All right. But basically, if you look at it, Ms. Lyman, effectively, it's going to be the cost, the water bill, and the 3 months of rent plus what's owed on September rent. That's going to comprise that amount.
All right, we will prepare.
All right. So it's the total amount is $12,932.20. Ma'am, I know that you were looking at getting everything paid by the end of the month. How long is it going to take you to come up with that? But you were looking at the 99,
I was looking at the
99, basically 10.
Okay, so I have to pay the water bill in whole instead of paying it in small increments like I was gonna do with the water company?
Yes. That was also part of the calculation that went in with the 17.
Right, but I'm saying,
Because I think she interfered with your ability to have a payment plan for the water.
so I can't do, the water bill.
Excuse me?
No, I'm saying I can't do the water bill in the payment plan?
She paid the water bill. You're supposed to pay that water bill as it becomes due. I understand what you were trying to do. Again, in the 1,700 that went into my calculation because and I'm not going to even ask because I don't get a straight answer as to why she did that, took it out of your name and the like. But I've taken all of that into account. And so now I'm asking you, and because I also understand that if the water bill were out of the mix, you would basically have around a little over 10,000 that would be due. So let me ask you this. Because you got about 13,000 that you got to pay. How are you going to get that paid? Because you're going to be coming up on January rent also, but this isn't included in this. Let me just ask you this. How much time are you going to need to get this paid?
A little after June,
Pardon?
a little after June.
Like, what does that mean?
Last week of January, February.
I can't give you that long because you're going to have January rent come again. You follow me? I mean, you're going to have that next 3,300 click again, which is going to kick this figure out. And Ms. Lyman, so that you also understand sort of the time frame that I'm working on. So you've got that coming up, but also today's what, the 9th. So the normal rent date in this case would be the 19th to pay it. But I heard what you said to me about when you were going to get the rest of that paid up. Here's what I'm going to do. All right. Listening to what you said.
And here's the final balancing act from the judge. He's giving extra time before eviction, but he's also laying down strict rules about how every payment must be applied. Translation. The court is trying to prevent this dispute from spiraling into yet another courtroom battle next month.
The order of eviction date on this matter will be January 5th, 2026. So that amount would need to be paid by that date. Now, so that, and I'm going to say this directly to you, Miss Anderson, the monies that come in must be applied to the judgment. So if she paid $3,300 and the judgment is still outstanding, applied to the judgment. You can't just say I've taken it as January and she still owes me this. It may be that if she gets that money all by that amount paid and it hasn't paid January rent at that moment, you're going to have to start over on another case. Am I clear on that? Am I clear on it? This is just simple math. Any monies that come in must be applied to the judgment. Don't come back in here having accepted $3,300 saying you're applying it elsewhere.
We understand that, Your Honor.
Thank you. I'll let your attorney explain that to you.
There's one point at the conclusion of this case. What is it that?
The 2 pen drives.
Yeah, she said the court has 2 pin drives that she'd like back.
You know what? She's been bugging me about those things, specifically direct to the court a motion of what she would like returned. And I will look at it, but nothing is going to be returned until the appeal period expires.
I have one other question. Do we prepare the judgment or does the court prepare the judgment?
I'll let you do it. All right. Thank you.
I'll talk to him.
Thank you. And Ms. Lyman, make sure you get a copy. At some point, they'll prepare the judgment. I'll sign off on it. Make sure you have a copy of it. Come up to the court, get a copy of it. All right. Thank you.
What makes this case fascinating is that both sides technically walk away with something. The landlord still wins a money judgment. But the tenant wins validation that the court believed there was interference and harassment, and honestly, that's why these landlord-tenant cases become so explosive. They stop being just about rent and start becoming deeply personal.